Bom dia, bom dia. Bom dia a todos. É um prazer receber aqui no Centro Cultural da Procuradoria o professor Dieter Grimm. Eu vou mudar para o inglês para ele nos entender. Good morning, everybody. It's a pleasure to receive Professor Grimm here in the State Attorney General's office. He made a great effort to be here with us because he was heading to an event at Porto Alegre, but he accepted our invitation to make this stop in Rio just to share his wisdom with us. Thank you very much, Professor. I would also like to thank our friend and colleague, Professor Ingo Sarlet from Rio Grande do Sul, because the partnership we have with him in the PUC of Rio Grande do Sul allow us to bring Professor Grimm here and other international professors that are very outstanding in their fields of studies. And I would also like to thank Professor Alice Voronoff, which is one of the most brilliant Brazilian minds in this field, Professor. So it's a pleasure to have you here, Alice. And thank you, everyone, for being here in a rainy Friday morning. Professor Grimm, the word is yours. Thank you very much.
Okay. Dear Professor Schreiber, dear Professor Voronoff, it's too close for me, a little bit, yeah. Ladies and gentlemen, thank you very much for this invitation. It's a real pleasure for me to return to Rio. It's not the first time that I speak in this institution. Since we deal with constitutional law, as a matter of fact, my first visit to Brazil happened in the year 1987 when the current constitution of Brazil was drafted. And I was in the country for, I think, 2 months to give lectures on all sorts of problems of constitutionalism. And I keep a fond memory of that. And I remember especially that there was a tremendous enthusiasm, especially among the younger generation, and a lot of trust in the Constitution, and there was the idea that as soon as we have the Constitution, everything will change and will be good. This, of course, is a little bit too optimistic, because constitutions in the very beginning are nothing but a text, and they have to be implemented, and there will be obstacles to implementation. What I also saw is that these tremendous hopes vested in the Constitution had the consequence that the Constitution is very long, yeah? One of the longest constitutions I know, and in particular the Bill of Rights is very extensive, and I think that creates more problem than it solves. But this is a different question. And sorry, not my subject of today, but the subject is the question whether constitutional adjudication is a legal or a political activity, and whether constitutional courts or general courts with thank you, with the power of judicial review are political or legal institutions. This question is all but new. The question is rather as old as judicial review is. That's to say, it's older than 200 years. But it has been posed ever since, and every generation anew discusses that question. It's discussed in academia, it's discussed in the media, it's discussed among politicians, and it's discussed in the general public. And I think it is an important question because depending on how you answer it, you have different consequences. Could judicial adjudication be political? it would be difficult to justify that political decisions of some impact are taken by judges who are neither elected nor accountable to the people, and that they are not accountable and don't stand for election, disqualifies them for political decisions. The judges' decisions are justifiable only if they are bound in a different way, namely through law, which means that their decisions are merely implementations of prior democratic decisions, which they enforce in cases of conflict. On the other hand, if this were doubtful, that judges are bound by law, and if judicial review would be therefore given up, as by the way is it increasingly advocated mainly in the United States, but also in other countries, then of course one would risk a loss of relevance of the Constitution for the political process. And this, of course, was the case in many countries and in many times of history where there were constitutions and very good constitutions, but no mechanism for the implementation and enforcement. Which answer is correct, political or legal, varies according to the academic disciplines that talk about this question. While legal scholars, at least legal scholars in Europe, regard judicial review overwhelmingly as a legal activity, political scientists lean to the contrary and think that it is a political activity, and it can also vary from country to country. In the US, also many legal scholars are convinced that judicial review is something political and not legal. The positions are rather rigid and they are rather inflexible. And if I nevertheless pick up that question once again, I do so because I have the hope that it helps to ask the question in a more differentiated way, so that the alternative is not either legal or political, but in what way and to what extent is constitutional adjudication political, and in what way and to what extent is it legal? I think with this question one avoids some misunderstandings. One avoids, on the one hand, the idealization that one can often observe when judges speak about their institution and say that their activity is completely determined by law and it's merely application to law, to the facts. And on the other hand, one avoids the hyper-realism that can be found particularly with US American observers who are inclined to say that I hope that works now. I think I move a little bit too often. So you find with American observers, political scientists, as well as Jews, very often the opinion that what judges do is taking political decisions and camouflage them as being legal decisions. If one approaches the object with the question that I suggest, I think it is rather easy to deal with two aspects of the problem. The first aspect, the object of constitutional adjudication is typically political. Different from the judiciary in general, constitutional adjudication deals with political behavior, more precisely with behavior of the political branches of government, including the legislature, whereas ordinary courts, for ordinary courts, political cases are the exception. So, for instance, if the behavior of a politician is a punishable offense. It's true that also in constitutional courts, there are a number of cases that do not concern the behavior of the highest organs of the states, but judgments of lower courts or administrative acts. And in Germany, these cases are even the vast majority of cases that the Constitutional Court deals with. 95% of all cases are individual complaints, mostly against judgments of lower courts. But quite often they also touch the political sphere, namely when the law that underlies an administrative act or a court judgment is challenged, when the constitutionality of the law is challenged. However, even if the number of cases that concern political behavior are small in number, these cases form the image of constitutional courts as political institutions. Checking the constitutionality of executive and legal aspects is the specialty of constitutional courts. Now, the second aspect, just as the object of judicial review is typically political, the effect of judicial review is typically political. Whether a law enters into force or not, or whether an international treaty may be ratified or not, whether the army may be deployed in a certain military conflict, whether the parliament may be dissolved or not, all these are questions of highest political impact, and all the examples have been taken from the jurisprudence of the German court, and there are only a small set of examples. That's to say, the political impact of constitutional adjudication is hardly questionable. We see that if we compare for a moment political systems with and without judicial review. Without judicial review, violations of the constitutions have no consequence. With constitutional review, unconstitutional acts can be quashed. Without judicial review, in cases of conflict, always the opinion of the majority prevails. In countries with judicial review, there is a more or less neutral institution, and also the opposition has a chance to prevail with its opinion of the meaning of the Constitution. And we should not only consider the ex post opinion, but also ex post effect. We should also look to the prospective effect, the mere possibility of a constitutional control of political acts makes it necessary that these acts are checked with regard to their constitutionality in a rather neutral way and in a rather early time in the political process. The mere possibility that there is an institution that is able to annul, to declare null and void political acts makes it necessary to take a very rather unbiased view of the Constitution. And in addition, the existence of judicial review has, and this is true for many countries, Germany certainly has an immense impact on the general political discourse. Political questions are very often, just because of the existence of a constitutional court, discussed under their constitutional aspect. So the fact that object and effect of constitutional adjudication is political finds an explanation in the institution itself. Constitutional courts and general courts with constitutional adjudication power have the task to enforce constitutional law. Constitutional law is the law that regulates the establishment and the exercise of political power. And the Constitution does not only organize the state, but it also regulates and limits and requires political behavior. And this is why constitutional courts may either interdict, but as well as require political activities. This is not a transgression of a borderline. This is what judicial review is all about. Constitutional courts that would avoid deciding matters just because they are political, have a political effect or a political object, would miss their function. there is no non-political constitutional adjudication. If someone finds this unacceptable, because, for instance, of his or her concept of democracy, he or she must reject constitutional adjudication altogether. This is not only a theoretical remark, but after the unprecedented expansion of judicial review in the second half of the 20th century, we now face more and more demands in the political world that judicial review should be abolished or at least limited. And I think also this country is not totally free from considerations like this. Yet those who share the opinion that it would be better, democratically better, to abolish judicial review have to be prepared to pay the price, and the price is the legal irrelevance of the constitutions. Constitutions, like all law, do not enforce themselves. They depend on being obeyed and if necessary, enforced. And if the compliance with constitutional law is left to the addressees of constitutional law, then the Constitution will often mostly be on the losing side. Of course, constitutional courts can only act by deciding cases that have been brought before them according to provisions that are stipulated in the Constitution. If object and effect of judicial review are inevitably political, the question as to whether the whole institution and the whole activity is political or is legal is narrowed to the third aspect, namely is narrowed to the inquiry whether the judicial activity, that's to say the interpretation and the application of constitutional norms to cases, is also political, or whether this is an aspect of the whole business that may be called legal. This question, I think, is decisive. However, it is very often neglected, especially in works of political scientists who deal with judicial review, because they are not familiar with legal interpretation and don't pay attention to what judges do before the outcome of a case comes. Functionally speaking, everything more or less clear. Judicial review is application of the law, hence an activity that merely executes predetermined general rules and applies them to a set of individual facts. However, this is not the last word. It's not the last word because it could be possible that the function cannot be fulfilled as intended. And as a matter of fact, that is a frequent assumption, either because the meaning of the Constitution is often extremely unclear, or because the way courts find their solution is unclear and intransparent. Still, one thing is clear in my view: the arena changes when the constitutionality of a political act is challenged before a constitutional court. The actors change, the criteria change, the procedure changes. Politics turns from subject to object. First, the actors. In the political arena, there are politicians in their various roles. In the legal arena, politicians change from the role of deciders to the role of applicants or respondents, while the leadership passes over to the judges. Judges differ from politicians in many ways. They are professionals of the law. Application of norms to cases is their usual job. They don't get their office by elections, public elections, general elections. So they don't need to campaign and to make promises. They don't come with an agenda. They don't become active on their own initiative, and they do not depend on external consensus. However, they owe their position to political decisions. There are many ways to appoint or elect constitutional judges. A wonderful field for comparative constitutional research to compare these different ways. In most countries that I know, politicians are involved in the appointment or election of judges, and this is not by mistake, as all holders of public authority need democratic legitimation, so also judges, and especially the highest judges, need a democratic legitimation, and this guarantees a certain influence to politicians. So it's not a misconception that they are involved. But most constitutions see the problem that goes along with it and take precautions that the appointment is not in the hands of the ruling party alone. However, right now, one can observe in many countries how politicians try to change the appointment structures of constitutional courts to get their hands on it, and especially to put it totally in the hands of the ruling party, very often the populist party. We have many, but quite a considerable number in Europe and outside Europe. Israel is the most recent case where this is happening. And I think requests like that are not unknown to a Brazilian audience as well. In functioning constitutional states, in addition, there is, of course, judicial independence. That's to say, judges are neither submitted to instructions nor subject to removal. And since their term is longer than a legislative term, they are not immediately affected by elections or by the formation of governments. But independence has, of course, not only an external side, but also an internal side. Judges have to feel themselves and act independently, which is very difficult to guarantee by law. So second, the criteria. In the political arena, party platforms, decisions of party conventions, coalition agreements, questions of expediency, question of financing, etc. In the juridical arena, exclusively constitutional law. This is not to say that constitutional law does not play a role in the political arena, but it comes rather late. It comes only as a corrective after the political will has been formed. So the question is asked whether the act that is found to be politically desirable is also legally permitted. And it's almost inevitable that under these conditions, politicians who ask the constitutional questions will be inclined to answer it through the lens of their political intentions. In court procedures, the constitutional question, which is secondary, which comes secondary in the political process, becomes the primary criterion. Now, thirdly, the procedure changes. The goal, of course, is to determine what the Constitution means with regard to a political decision that is challenged before the court, and what the legal consequences are. Consequently, it is not an act of will, but it's an act of cognition, and only legal arguments are allowed, admissible. Of course, it may be contested what a legal argument is, but it is not doubtful that non-legal arguments are inadmissible. Whether a decision is wise or whether a decision is affordable or whether a decision is useful or damaging for the national industry, all these questions are irrelevant. So I would like to draw a first conclusion from what I said up to now. Judicial review is certainly not political in the sense that resembles the activity of political parties or the activity of parliaments or governments or international conferences. But this is again not the end of the discussion. What is clear so far is that the political conflict enters into a different stage where it is carried on under different conditions and restricted to constitutional aspects. What is open is whether the judicial actors who now decide are so bound to the legal criteria that are now relevant or let themselves to be bound by them, that there is no room for political considerations. That means that we can narrow down the question whether constitutional adjudication is political or legal to the process of interpretation and application of constitutional provisions. If this process, in spite of the political character of object and effect of judicial review, is in itself juridical or not, this is the decisive question. Regarding the actors of judicial review, observation of the judicial process with empirical methods is limited. In almost all countries, the principle of the secrecy of deliberation is manifested. That makes judgments a black box for observers, either in the general public or the media or in the science. The countries who deliberate, where the judges deliberate publicly, are less than a handful, but Brazil is the most important country where deliberation is not only public but even televised. But I never know really whether then the deliberation is the place where the decision is really taken or not. But this is something where you have insights in your own system, which I do not have. In Germany and most other countries, the deliberation is secret. In Germany, not even minutes are taken from the deliberation. It's not recorded, so that not even ex post historians or social scientists have a possibility to research how a deliberation is brought about. I may add a remark that we had in our previous conversation before we went to this room. In the German Constitutional Court, of which I was a member for 12 years, I don't know whether it was mentioned or not, it's totally normal that judges change their mind because of the argumentation in the deliberation. It's a total normal act which doesn't cost any judge its reputation. It's a reputation or reputation. But I doubt whether this would be the same if the deliberation were public. I guess then we would have a different system in this respect. So, difficult to know what happens once the oral argument or the hearing is over. At best, we have self-descriptions of judges, but how reliable are the self-descriptions of judges? Which judge would say, I don't care about the law, I decide according to political preferences? Even if he did, he would probably hesitate to admit that in public. And so what we have in this field is a lot of speculation in academic writings on judicial decision-making, and especially in the social sciences, political science. I'll come back to that in a moment. Anyway, there is an indirect access of court. Judges give reasons and make the reasons public. And the reasons are presented as acts of cognition, not acts of will. Judges tell how and why the judgment follows from provisions of the Constitution. If there are dissenting opinions, then even a deeper insight is possible because the controversies within the court may be laid open. However, it is well known that making and presenting a judgment may differ. As a matter of fact, many social scientists, but also parts of the legal science, especially in the US, assume that judges purport only to derive their judgments from the law, but in fact do something else. They are regarded as strategic actors who pursue institutional interests or personal interests at any rate, follow non-legal preferences, but present their decisions as if the results had followed by necessity from the norms, whereas in reality the norms don't play a role. This view, which is, as I said, is very, very lively existent in the United States, is prescribed as a realistic view of what happens in courtrooms. Of course, one cannot deny that this exists. There are judges who follow their own interests or preferences. There are judges who give institutional interests of judiciary greater weight than the law. There are judges who try to avoid conflicts with power holders. But the question for me is this typical? Does it come along with judicial review by necessity, or is this the pathological case? I would like to mention in this context one political scientist who does what most political scientists omit. He analyzes the reasoning of courts in courts' opinions. It's David Robertson, Oxford political scientist, and he compares 8 countries where judicial review or constitutional adjudication exists, and he reaches the result that legal argumentation is characteristic for the judicial activity. For him, and I quote him now, it seems simply beyond credibility that so many thousands of professionally socialized and able men and women should be lying or deluding themselves in their arguments. This, of course, is an argument based on plausibility, and that means that it is less reliable than empirical research. But as we said, the core of judicial behavior is not open to empirical research, and the realists, the so-called realists, don't have exclusive insights into the judicial proceedings as well. Rather, they derive their assumption from a preconceived theory, and this is the theory of rational choice, of which it is by no means clear whether it is able to grasp the judicial activity. When I continue now and speak of judges, I want to speak of the judge who takes his or her job seriously, well knowing that alternatives exist. The judge who decides legal problems on the basis of law by applying legal methods. And when I speak of this, I don't speak of an ideal type that can only be approximated, but I think I speak of a judicial reality. It corresponds with my own experience, by the way. I had the experience that in the deliberations, I mentioned it already, of the German court, legal argumentation method. And it was normal, as I said, that people changed their mind. And where it's maybe true that making and presenting a decision are not the same, but they are not isolated. Either the legal form imposes certain constraints on what can be said in a judgment. But also with this statement, I think we did not yet reach the end of the discussion, because even the most serious attempt to solve problems legally could be in vain. Could be in vain if the text of the Constitution were so empty or so unclear that non-legal considerations would be necessary. So I think I have to limit or to narrow the focus of the inquiry once more and ask the question if or to what extent the interpretation and application of constitutional norms is in itself political. That's to say, the problem thereby shifts from the willingness of judges to follow constitutional provisions to the capacity of constitutional norms to bind judicial behavior. And the emphasis is therefore no longer on actors, but on the process of interpretation. Interpretation is inevitable. No application of a constitutional norm without prior interpretation. This is a necessity and follows from the nature of legal norms, different from an order, which refers to an already existing situation and exhausts itself in an act of implementation. Legal norms refer to an unforeseeable number of future situations. They are therefore formulated in a more or less abstract and general way, whereas the cases to which they apply are always individual and concrete. Hence, there is a gap between norm and case. The norm is not immediately applicable. The gap has to be bridged by interpretation. And that means deriving from the abstract and general norm a more concrete rule that fits the peculiarities of the case and makes the norm applicable in the first place to the case. That can be easy or difficult, request shorter or longer chains of arguments, but no norm is so clear that there are never doubts as to the meaning for a case. Whether a constitutional norm is vague and open-ended can be ascertained by reading the norm. Whether the meaning of a norm is clear and unambiguous cannot be determined independently of the case. One and the same norm can be clear with regard to one set of cases and unclear with regard to another set of cases. Constitutional norms are more vague than statutory law. That's to say, the gap between norm and case is larger, which means also that there is more leeway for the interpreter. It's not open for any meaning. Leeway has borders, but mostly there is more than one meaning which is compatible with the text. Interpretation is therefore not a purely cognitive process. Interpretation is not only uncovering a meaning that has been deposited in the norm from the very beginning, from the time of enactment on, but concretization is to a certain extent construction of the meaning of the norm, not just finding a pre-existing meaning, but to a certain extent a construction of the meaning. If this were sufficient to prove that the application of norms to cases is by nature political, then every adjudication, regardless of which field, would be a political act. But if it were true that where the certainty of the meaning ends, politics begin, then everything in the legal field is politics. Yet I think one would not take into account that where the certainty of the text ends, legal reasoning does not end, but legal reasoning continues. The space of uncertainty is filled by legal means. There are methods how to make vague norms nevertheless applicable so that the procedure is legally guided. We have doctrine, we have a legal methodology, we have precedents. Doctrine and precedents are a reservoir of accepted and proven interpretations so that not every judge in every case has to be at scratch. Methods offer ways to concretize vague norms in a rational way and a way to distinguish legal arguments from non-legal arguments. However, neither doctrine nor method bind the interpretation in the same way that legal norms bind. They are the result of a constant work with the law in which legal scholars and practitioners participate, and the process is rarely uncontested and it is never finished. Different methods and different doctrines are competing. The border between legal arguments and non-legal arguments changes over time. In the 19th century, what we do now all the time, namely interpret laws purposive, that's to say with the goal in mind, was regarded as political interpretation in the 19th century, and everybody knows about the ongoing dispute in the United States Supreme Court whether the Constitution may be only understood in the way it was understood by the founding fathers, or whether it is, as they say, a living tree that can be adapted to new challenges. All that doesn't mean that anything goes. There are interpretations which are clearly wrong, independent of which doctrine or which method you apply. It means outside the scope that the text leaves. If within the scope different opinions among judges exist, there are still legal differences. And however, it is undeniable that the judge is obliged to render decisions which are not completely determined by the law. So therefore, one last attempt to narrow the problem, the question, what determines the choice between different but legally possible solutions? Is this finally the moment where political convictions, party affinities, etc. prevail? There's a certain branch in social science that wants to infer judicial behavior from the social data of judges, so family background, education, religion, etc. That would presuppose that there is a causal relation between these elements and the judgments. So let's say that a landlord would always decide against tenants, and that a believer would always decide in favor of the church, but this is extremely crude. I wouldn't even give it the name theory, with which I wouldn't deal very long, but more serious is this theory that judges use institutional interests in deciding cases, that they decide with the intent in mind to maximize judicial power. And again, that may happen. There are experience and examples where this is true, yet I would say under normal conditions, it is not the case. It is an underestimation of the specific logic of the legal system and of the relative autonomy of the legal process and the legal decision-making. Also, it does not distinguish sufficiently between intention and effect. The intent is to effectuate the purpose of the norm in the best possible way. The effect is an enlargement of the powers of the court. What then is decisive in this last stage? Prior commitment to ideas of justice, for instance, background assumptions. These things are not, these things are not purely subjective. Many reflect general views or tendencies of the time being. So attitudes vis-à-vis the gender problem might influence the interpretation of the equality clauses of the Constitution, or background assumptions about the regulatory capacity of market or of state may influence the interpretation of economic rights, or views about the function of the Constitution, a framework or a directive may influence the concept of a judge, of that judge is a more activist or a more deferent judge. Each judge, I think, each judge works under the imperative to render a legally correct decision without the norms precisely telling him what the correct decision is. That's to say, every judge must reach individual certainty in the process of interpretation, but every judge must at the same time acknowledge that another judge may reach a different result without having necessarily committed a mistake or having argued outside the law. So I think that the certainty, the expectations of certainty that come from a general public are of course understandable, but one should not exaggerate the expectations as to the certainty of the law. The certainty of the law is not yet there when the law enters into force. It is completed only in the act of application. Prior views, background assumptions are not legal in the strict sense, but they are not extra-legal either. They are integrated in the process of interpretation. They don't exercise their influence directly, unfiltered, so to say, but they have an indirect effect. They are mediated by norms and mitigated by the fact that adjudication is a collective business. So my conclusion would be that there are sufficient bonds that allow to call the judicial activity a legal activity, not a political activity, but there is a certain rest. But for me, the rest, it's not so overwhelmingly big that we would have to draw the conclusion, oh, that has nothing to do with the law, but is political. However, and here I come to my end, however, one can never exclude that judges miss their function or abuse their possibilities or lose contact with the society for which they take the decisions. So correctives are necessary. Correctives are necessary, and correctives are, for instance, the observation of what happens in courts in the legal science, also the observation by the public debate, not in the sense that judges should follow public opinion, but reflect their own activity in the view of public opinion. And I think that this has an impact because judges are aware of the vulnerability of the institutions. But in the end, I think also a real counterweight, these are only indirect motivational means, a real counterweight is necessary in order to minimize the democratic risk of judicial review. The jurisprudence, also that of constitutional courts, has to be subject to correction by legislation, and in case of the Constitution, by amending the Constitution, not in the sense of the override system in Canada, where the Constitution allows that Parliament ignores a decision of the court that a law is null and void. This, again, is frequently recommended nowadays as a better means of judicial review, this weak form, but not directly my opinion. The democratically correct form is the constitutional amendment, and I think this has to be existent, and this also means that constitutional amendment shouldn't be too difficult, which is, as we can see in the case of the United States, the case, but it shouldn't be too easy either. And in my own country, I think it is a little bit too easy. But maybe for Brazil it's the same. At least the number of amendments Brazil overrides, so to say. The German experience, where also the number of constitutional amendments have not been small. Thank you very much.
Thank you, Professor Grimm, for your conference. I will now open the room for Professor Voronoff, and if you allow us, after, we may have questions from the audience here to you. Thank you very much.
Thank you so much, Professor Grimm, Professor Anderson. In advance, I apologize for my English. I'll try to transmit my ideas. And I think the lessons, the reflections are very important inadequate for, especially for our moment in Brazil, especially today. And I say today literally because we have been discussing the dichotomy between political and legal dimensions of the constitutional adjudication for a long time. And it was part of the justification and the capacity of people to receive the decisions of Supreme Court. And okay, it's part of the game, the dialogue of the institutions. But I think yesterday we had, for the first time, a concrete initiative from our Senate to interfere in a more concrete way. And we know in Brazil, yesterday was a very hot day. I will read my notes. The Senate approved in 2 rounds and forwarded to the chambers of deputies the proposed constitutional amendment, Amendment 8, 2031, that limits the actions of the ministers of the Supreme Federal Court. This amendment prohibits monocratic decisions that suspend the effectiveness of laws or acts of the president of other branch of government. Just after this approval, the reactions, both from ministers of the Supreme Court and the president of the Senate, were very hot, were very loud. For example, Gilmar Mendes, our minister, said, quote, "The STF does not admit intimidations. Propagators of institutional chaos won't be admitted here." And Alexandre de Moraes, another minister, said, they are attacking the independence of the STF. And, for example, our capacity, our power to, in a monocratic way, decide things was very important in the pandemic moment. So we had to decide very quickly to deal with the chaos, to protect people and fundamental rights of people. And what will be if we don't have this power? What will be the consequences for the fundamental rights? So my questions go around these worries we have here. What is the risk of these measures for the protection of fundamental rights? What cost we will pay? And one more, how our Supreme Court should react after this, because we know the last voice will be Supreme Court's voice. So probably this change in the rules will be in the Supreme Court, and the ministers will have to decide about the constitutionality or unconstitutionality of these measures. So it's better to, in this situation, maybe dialogue and be different to the change the parliament did, or it's better to react in a very offensive way to avoid another measures, because we know in our Congress we have another proposals trying to interfere in our Supreme Court, and for us, I'm afraid of all these movements. Thank you.
I must confess, I have increasing problems with my ears, and the microphone made it not better, but worse to understand. Yeah, could you briefly say it without micro?
Yes, yes. I'm asking about the consequence of this amendment the Senate approved yesterday to limit the power of the ministers to decide alone about the constitutionality of rules, the constitutionality of executive acts. And I said, we are very afraid of this because, for example, in the pandemic, this power was very important to protect fundamental rights. So what will be, how we will stay without, with this? And more than this, how does the Supreme Court should react? Because after this, maybe we will have another different tentatives, to interfere.
Okay, But before,
And the Supreme Court will analyze if this measure approved by the Senate state, if it is constitutional.
Okay,
How should the Supreme Court
unfortunately, these are questions that we face in many countries more and more. And it is it's very difficult, I think, to give a good answer. On the one hand, I would, of course, confirm the right of the constitution maker, that's to say the legislative bodies in Brazil, also to change the conditions under which a constitutional court may act. That's to say limit it or introduce higher hurdles before they decide, etc. But on the other hand, we see there may be very different motives. And the motive may be to correct maybe an aberration or to correct a misuse, but the motive might also be to just disempower the constitutional court, the controlling institutions. And this is very difficult to distinguish. So if I can for a moment give the European experience in Europe, in the European Union, the countries that fundamentally changed the role of their constitutional courts were Hungary and Poland after a populist government came to power after free elections. Every single measure that they took would find some equivalent in another country which is doubtfully a democratic, rule of law abiding country. So you think you can only really understand it if you don't single out a certain measure, but whether you look, what is the motivation behind it? Is the motivation a transformation of the regime from democracy and rule of law to a more authoritarian regime? And this is, of course, difficult. Motivations are more difficult to find. But this would be, for me, the most important question. Is it an attempt, the first step maybe, to a regime transformation, or is it below this threshold? Then comes the question that, of course, the Constitutional Court is in a position to review the constitutional amendment as to its constitutionality, provided that there is a supernorm in the Constitution. We have that in Germany in form of Article 79, which says that certain principles of the Constitution are unamendable. We have had no case where a constitutional amendment was used in order to limit the powers of the court. These were all 3 cases only, as far as I see, which did not concern the powers of the court. And in none of these 3 cases, the court found that a constitutional amendment was unconstitutional. But the court has the power. But when the question is, the own powers of the court have to be reviewed. This is, of course, a delicate question for a constitutional court. The court is, so to say, party in its own affairs. And let's say if the rules of the procedure are concerned, then the question is, according to which rules do you review the new rules, according to the old ones or to the new ones? If you review it to the new ones, the criterion and the object are the same, so this doesn't work logically. So we have to do it according to the old rules of procedure. So these are the problems that I see, and I don't want to make any, don't want to pronounce any view about the Brazilian case. Should be in a position of more knowledge, but I think this is the real question. I think it's a very important question that you raise.
I have another question. Can I make another question?
Just, for me, the shorter
yes.
Yeah, thank you.
As I was invited, I have to enjoy this moment. Yes. For me, was, Minister Barroso was in the position, he is in the position in the Supreme Court as our president. And in his speech, he identified important drives to conduct his management in the Supreme Court. Mm-hmm. So he said, for him, it's very important to put energy in the communication, improving the interaction with society, explaining our role in simple language, didactically explaining decisions, dispelling misunderstandings and misinterpretations. And a second drive was about relationship. And he said, the judiciary must be technical and impartial, but not isolated from society. We need to be open to the world with eyes to see and ears to hear the social sentiment. In life, we should be windows and not mirrors, having the capacity to look at others and not just at ourselves. So my question involving this political role that is part of constitutional adjudication is there an ideal point of sensitivity to public opinion? How the court has to deal with this public opinion? What's the role of public opinion in their job? Was clear, Professor?
Yeah, that would be I think we are in a period of time where many Supreme Courts or constitutional courts feel more resistance, not only from politicians, but more resistance or missing understanding in society as well. And so I would say that a certain reaction to that might be necessary. Normally, a court speaks through the opinion that he renders, and this is the only way to communicate for a court. But I think it may be true that in situations of tension, this might not be enough. In the first place, of course, I would expect that the court writes opinions in a way that they are understandable also for the general public. So this is the way the court expresses how it fulfills its function. And very often judgments are, I don't know about Brazil, but in Europe judgments are too technically formulated so that they are readable for the lower judges who shall not commit the same mistake again that they made, but not readable for the general public. So I think it is a moral duty of courts to write their opinions that they are also generally understandable. I know, of course, that the general public doesn't read the opinions. It reads them through the way the press reports about them. The ordinary, even the educated person wouldn't read a German constitutional court judgment. But of course, the press reports on it, and the TV and media report on it. And so I think that also contacts with the media are a necessary step for a court to make itself understood. But this should be the only motive. The only motive should be to be understood. I also wouldn't object if judges appear in public and give a talk, not on cases that they decided, but on the role of the judiciary. I think this is normal and helpful. But also, again, the borderline is difficult to draw, especially also the borderline, but this was not your question, about contacts with politicians. I was in the 2 days ago in the Suprema Tribunal Federal, and this question came up, and the President Barroso, whom you quoted, said, well, this is normally, we have constant contacts with politics. which surprised me away because we never have contacts with politics. It would be regarded as inappropriate in Germany. And if you meet them, which happens less because the Supreme Court in Germany and the Constitutional Court are never in the place where the government is, so one doesn't meet them as frequently as if it may be the case in Brazil. But if one meets them, it would be inappropriate to talk about cases. But a small talk, I mean, doesn't hurt. Yeah.
Thank you. Thank you. Do you want to ask some questions?
So now we will open for questions from the audience. Se alguém quiser fazer a pergunta em português, a gente traduz aqui, e se quiser fazer em inglês, naturalmente, fica totalmente à vontade.
Guten Morgen, Herr Professor Grimm. Danke, vielen Dank für Ihre interessante Vorlesung. Können Sie hören mich? Nicht? Können Sie hören mich? Ah, tá.
Professor Voronoff will help me.
Okay. Können Sie hören mich?
Yeah, I hear you much better without micro than with.
Okay, Entschuldigung, meine schreckliche Straßdeutsch. Ich möchte eine kurze Frage stellen, aber in English. So, my question is, if I understand you well, your main thesis is that political judicial review does not have a political function. Maybe, and this is maybe because of a misconception of political scientists and the legal scholars sees as a classical model interpretation as an application of concepts, of legal concepts. But in the 18th century, the main problem was monarchy. So Montesquieu said all the powers could abuse their own power. So we have to do something. And the problem was the terror, the terror regime. Parliament became the problem, the tyrants. So in the 20th century, Carl Schmitt said the judicial review, when treat political questions, could be politicized. We can judicialization of politics leads to politicization of judicial review, and that's the problem. So scholars now talk of juristocracy, magistocracy. Do you think that this problem can the juristocracy be a real threat to become a tyranny in the future? That's my question.
I would not deny that constitutional courts or general courts have a political function. I mean, if you have the power to declare laws unconstitutional, this is evidently a political function. But my but comes, this function has to be educated by legal means and narrowed down to legal means. That's all the questions that surround a political decision are singled out, and the question remains constitutional, yes or not. This question, again, as I said, leaves usually more than one solution open, and it's interesting to see to what extent individual interests come into the play. But with doctrine, with methodology, I think one keeps the gap rather small. So if this happens, so to say, if the function is exercised in a serious way, I am not so concerned about it. Nevertheless, the warning of Carl Schmitt has to be taken serious. the more powers the court have, the more interested is the politicians to influence what courts do. This is, I think, what he means by politicization of courts. And maybe this is an argument also for political self-restraint of courts. If courts become too activist, I wouldn't even say active, but too activist, then, of course, the inclination of politics to influence them grows. And we have quite a number of examples for that. For instance, to give one example, the Hungarian Constitutional Court, which is now totally in the hands of the ruling party of Viktor Orban. All other judges have been ousted and they are only loyal party members, so the government doesn't have to fear anything. I'm far from justifying that. I find it deplorable, but this court was extremely activist and declared in the early years after 1989, 1990, 30% of all laws unconstitutional. And asked, this is really necessary. He said, well, this is Western standard. This is by no means Western standard. I think the German Constitutional Court may declare 2 or 3% of all laws unconstitutional. So the reaction of the ruling party, which I don't defend, finds perhaps an explanation in the extremely activist role in the previous period of the Hungarian history.
Thank you, Professor. Mais alguém? Uma pergunta? Alice, quer fazer mais uma?
Related to this political dimension, I think we have been seeing that the nominations to Supreme Court in Brazil have been very disputed. And I think in the past, the president used it to take some attention to the consequence of his indications or her indications. For example, nowadays we have 11 ministers, we have 2 women, and one of these women will retire and we'll have a vacancy, an open place there. And for example, we women have been arguing in a very intensive way to put another woman there because it's very important for us, for our representation, to have this point of view, diversity, and it's very clear that this is not an option for our president because, for example, the last vacancy, the minister who was nominated was his lawyer. It's a very competent person, but it was his lawyer, and he's very worried about putting someone who is loyal to him because he knows the political aspects, the political decisions are very, it's the way we do this now. So if, Professor, you can talk a little about these procedures and representation of people in Supreme Court and procedures, if they are okay, it's part of the game, they are all political procedures of, yes, this is important in a democratic, constitutional, democratic state to think about this procedure and having a kind of control and representation.
And Professor, one other question. One of the measures that the Senate is proposing or discussing right now is imposing a time limit for each judge to stay at the Supreme Court. So nowadays it will last forever. So what do you think about that?
I take your remark first. it shows the importance of the rules for appointing or electing judges. I think this one cannot overestimate the importance. The German example, we have 16 judges in the Constitutional Court. Half of them are elected by one House of Parliament, the other half by the other House of Parliament. But this is not very important because the political parties arrange themselves independently of which House votes. But important is a two-thirds majority. And a two-thirds majority prevents that ever the ruling party alone can fill the vacancies. They always have to find the agreement of the opposition, which up to now has prevented strong partisan people in the court. And the professional quality of people was more important than loyalty. And no judge feels obliged to one party alone, but the judge is appointed only when minority and majority agree. So there is no special loyalty of judges. And this has been a very healthy effect in Germany. I wouldn't say that it works the same way in other countries because there are always surrounding contexts. But in Germany, it was, I think, the most important, the two-thirds majority, the most important guarantee that the court was not politicized. Limiting the term, I mean, you lie between what is normal, that constitutional court judges are limited in term, and the United States, where they serve until they die, and you have a lifetime, but a mandatory retirement age, 75, I think. So I think it's extremely important not to use not to copy the American example. And with regard to limiting the time, what you said about female judges is also a question of how do you guarantee that more or less the highest court is in contact with societal developments, which I don't understand as that courts should follow public opinion, but what is important for a society, what are the major conflicts, should perhaps find some expression. And when you say there is one woman, if I understand it, and one vacancy, I can again say that for a very long time in Germany, we had only from the very beginning one woman, but very long among these 16, one, but now it's equal. So 8 women, 8 men. And because in order to guarantee this reflection of the society in the court, I would have some understanding for saying a limited term, which number of years doesn't matter really. In Europe, I think the usual is 9 years. The German Constitutional Court has 12 years. If you up to now had 75 and say 15, I mean, this is secondary, how many years. But I have some sympathy for having limited terms, not in the ordinary judiciary, but in these apex courts, yes.
Thank you very much. Thank you very much, Professor. Any other question? So thank you very much for your presence in Rio. I hope you can come back as soon as possible. We love to have you here, and we wish you a good comeback to Germany.
Thank you very much.